Hello and welcome again. Some viewers will have been following my exchanges with self-professed expert in pseudo-law, Robert Sudi, both in these videos and on my Telegram channel, also named Locked on Article 61, the link to which is in the comments box. I'm grateful to Mr. Sudi for taking the trouble to express in one convenient location so many of the fallacious arguments employed by those with a vested interest in trying to negate the legem terrae, the law of the land. His attitude is a distillation of those of the legalists who aver that the law is whatever any group who can usurp power and enforce their will at sword or gunpoint decide that it shall be. Of course, this is done by erecting a framework of pseudo-legitimate corporate bodies, such as parliaments, judiciaries and constabularies. All of these organisations are established by convincing the population that they each have the right to cast a vote for the election of legislative representatives. And as far as that goes, there's nothing wrong with that. Why shouldn't people who want to stand for public office place themselves before the populace and state their qualifications, in the hope that the voters will discern which of them are the most suitable for the task? The problem comes when, in addition to assuming the relevant office, it's accepted almost universally that this election grants to those office bearers extra rights or privileges that are not available to non-office bearers, such as the privilege of extorting taxes without consent, issuing directives which must be obeyed, irrespective of any moral principles involved, on pain of punishment administered by armed squads of pseudo-constables. Those running this system are most diligent in avoiding, indeed quelling, any observations that if no individual has the right to enforce their will onto another individual, how this non-existent authority can be somehow transferred to another party for them to use at their discretion and especially for their personal profit. They take great pains to obscure from the common people that there exist certain immutable laws which have been recognised for centuries, if not millennia, that explicitly prohibit such activities and class them as unlawful. The dispute between the Sudis of this world and the upholders of the true common or constitutional law boils down to this one issue. Are we to accept this agglomeration of concocted rules, welded haphazardly onto each other, in the fashion of droplets of molten metal spilling from an industrial ladle onto the mess made by countless other droplets spilt over the centuries? Or are we to abide by the principles which state that every individual has no more rights and privileges than any other, and have the law of the land administered according to this existing law, which predates all of these obfuscations and places the control of the law into the hands of the people, its only correct administrators? Here's a quote from Mr. Sudi on the issue. Quote, "Again, the assertion that it's not law, and there's a difference between law and legislation, are not justiciable arguments, and there's plenty of decisions I can refer to that confirm principles such as parliamentary supremacy, principles which are likewise binding on every court in Australia. Your meanderings are simply not arguable, provide no remedy for anything, and there's nothing you can possibly say that can change that." End quote. The arguments placed in the thread that because a parliament or a court says something, it must ipso facto be true, are easily rebutted. What if the courts, like the ones in Germany in the 1930s, or numerous other authoritarian regimes, decide that any number of morally and intellectually justified human rights are, as Sudi says, not justiciable? Are we not to dispute such obvious wrongdoings? Does Robert Sudi therefore acquiesce to the atrocities thus committed? Does he somehow celebrate the execution of the White Rose students during the war, as it perfectly highlights his argument that the law is what it is and we should all shut up when we see such abominations? The point is that what we have operating now in Australia differs from those regimes only in degree, not principle. And how much of a difference in degree is it when people can be assaulted by fake constables, locked up without trial, and deprived of livelihood for standing up for the right to bodily autonomy? Sorry, Mr. Sudi, but you're totally wrong. There is indeed a great deal which we can say to eventually bring about change. Not immediately, no one is arguing that, but over time, when enough people come to understand the principle I'm going to discuss now, the adoption of which will go a long way to dismantling this unlawful, indeed criminal maladministration which is affecting us all. It even affects Mr. Sudi, though he doesn't realise it. He used to stand for freedom without properly understanding the principles why he was correct. But self-confessed serial human rights abuser David Halpern opened the door to a mental prison cell, and Robert Sudi walked right in, accepting the idea that supercilious snobs like Halpern and his ilk have the right to rule over everyone else. But let's proceed to this principle. It is, of course, the concept of trial by jury. This has been discussed a few times before in this series. But the further along this path of increasing infringement of basic birthrights, the closer we come to the crux, that point where the people's control of the law is either retained or lost. The irony is that the issue is not whether we regain this right, because it already exists in law, as we shall see, but whether it is expunged by legislation or properly acknowledged. Any attempt to expunge it by legislation would of course only be putative, since there is no lawful authority by which it can be abolished, just as there has never been any lawful authority by which Magna Carta 1215 may be abolished. But allowing such an unlawful act to emanate from our parliaments would make the task of resurrecting the principle in the minds of the public and getting them to prevail over the existing governments for its repeal much more difficult. It's a classic case of an ounce of prevention is better than a pound of cure. The system of trial by jury had been around and in force for hundreds of years before Magna Carta. Alfred the Great standardised the practice in the newly unified kingdom and was so strong in support of it that he hanged 2 judges who went against the wishes of the jury. He was understood to have taken a great interest in as many of the cases in his kingdom as possible, often looking into them to see if they had been just verdicts, etc. He insisted on his judges being literate, so that they had the ability to study and learn to improve their skills. In those days, the juries were mostly local village juries, and the accused and accusers usually knew each other. But all members of the local communities accepted that they had a responsibility to uphold law and order. The trial by jury system described in Magna Carta 1215 gained much momentum during the reign of Henry II in the late 12th century. In Magna Carta 1215, Article 39 specifies that no one should be proceeded against by any authoritative official or body until the accused had been tried by a jury of their peers or the law of the land. Whether this ostensible alternative referred to 2 ways of describing the same thing or not, subsequent iterations of imposed legal systems decided that it meant they were 2 different things, which is used today to deny people requesting their Magna Carta right to a trial by jury, insisting that being subjected to the judgment of a solitary magistrate or judge is, from the point of view of justice, just as good as a trial by jury. This is in direct contradiction and infraction of Article 40, which states that justice will neither be delayed nor bear financial cost to anyone seeking to use or be processed by the judicial system. The system is supposed to be publicly funded and consist only of disputes between individuals. Otherwise, how could the state, which is charged with administering the system, actually be one of the parties to the dispute and also remain impartial? That is the meaning of Article 39, arguably even more important than the question of how the proceedings are to take place. It certainly resolves the issue of which is the correct method, trial by jury or the arbitrary judgment of a state-employed official. A study of history shows that trial by jury was one of the first planks of the judicial platform erected by Magna Carta to be undermined. First came the insertion of the qualification of people for their right to sit on a jury by stipulating certain wealth requirements. By 1270, virtually all commoners had effectively been barred from jury service, leaving only the most wealthy and influential members of the community wielding the baton of justice. Does anyone wonder if this had an overall effect on the administration of justice over time? One is reminded of the car bumper sticker seen years ago in Perth, Western Australia, which stated, "The upper crust, a lot of crumbs sticking together." Having excluded most people from the process of administering justice, it became progressively easier to condition subsequent generations to further distortions of judicial principles, with the result that even learned practitioners and jurists, often held up as champions of the common law, also produced statements virtually diametrically opposed to such principles. Once again, I'm indebted to Robert Sudi for this quote from Sir Edward Coke. Quote, "So what do you think of the champion of the common law, Sir Edward Coke, in his fourth part of the Institutes of the Law of England, at 3638, accepting that Magna Carta could be altered by the English Parliament, describing Parliament's power as transcendent and absolute, not confined either for causes or persons within any bounds, while contemplating the enactment of bills of attainder without trial and statutes contrary to Magna Carta without any suggestion of their invalidity," as Dawson J. pointed out in Cable versus Director of Public Prosecutions, New South Wales, 1996. A bill of attainder is a legislative act that declares someone guilty of a crime and punishes them, often without a trial. The legislature adopted the bill and the monarch formally assented. The bill declared a person or group guilty of a crime, usually treason. The bill punished the person, often with execution, and the bill took away the person's civil rights, such as the right to own property. Such bills obviously deprived the accused of a fair trial. They were often post facto, meaning that they'd made past conduct a crime, and most dangerous of all, they allowed the executive or legislature to usurp the power of the courts. My reply to Mr. Sudi's question was simple. What do I think of it? He's wrong, that's what. An individual making such statements shows at least a confused state of mind if they wish to be considered a champion of the common law. It also raises a question of whether they really are such a champion, or perhaps a Trojan horse, appearing to be a gift, but withholding deadly secrets and antipathetic forces within. If we give Coke the benefit of the doubt and accept that he was simply confused as to the true nature of law, and he was a learned jurist, is it any wonder that extremely few people today have even such a flawed understanding as did he? Certainly it's easy to see why someone like Robert Sudi could be easily misled by a sophist of David Halpin's relatively low position on the totem pole of legalism. The pitfalls of basing philosophical constructs on such flawed concepts of law as the abandonment of universal moral principles and the exercise of coercion and, if necessary, raw violence, stand as exposed as the naked emperor in the famous story, able to be called out by nothing more sophisticated than a child's observations. Next time, we're going into some of the modern convolutions of thought on the practices of jury performance and independence. Thank you for watching.